Hi everyone, I'm Bina Delisi, and in this video we're going to talk about remedies available to tenants if a landlord serves an N12 notice in bad faith. Landlords, listen up. Oftentimes we get calls from landlords asking, can we serve an N12 notice to just get the tenant out so that we can either re-rent the property or sell the property? The N12 notice has a good faith factor. And what that means is that it has to be served with clean hands, meaning that as a landlord, you cannot use the N12 notice as a loophole in order to end the tenancy for whatever reason. If the tenant is disrespectful to you, if they're not paying the rent on time, if they're causing damages, if they've blocked you from social media, or if they're not responding to your text messages or emails, again, the N12 notice cannot be used as a loophole in order to end tenancy. And if it is, the tenant has recourse. And what I mean by recourse is that they can bring forward a T5 bad faith application against the landlord if they feel that they've been evicted or if they've left without real cause. And if the landlord re-rents the property or decides to sell the property. Some of the remedies that a tenant can seek is the rent times 12 months, the rent differential times 12 months. They can seek moving costs or storage fees, basically any out-of-pocket costs that they've incurred as a result of having to move. And basically, the other last thing that they can ask the board to order is a remedy or a fine satisfactory to the landlord and tenant board. The jurisdiction of the landlord and tenant board is up to $35,000, meaning that the board only has the authority and the power to issue orders only up to $35,000. However, if the tenant can prove that they have suffered damages or losses over $35,000, then they can apply to the divisional court and seek higher costs. We hope you find this video informative. If you have any questions, call us first.